Janya Singh Sirohi, currently working as a legal associate with NRI Legal Services. Today in this video, I will be telling you about the rights and obligations of landlords and tenants, their relationship inter se, which is a multifarious one, and the laws governing their relationship. Also, whether disputes between landlords and tenants are arbitrable under the present law or not. For this, we have to understand why the Central Rent Control Act came into being. It was formulated to formalize the relationship between landlords and tenants so that none of the parties can exploit each other. I would also like to add herein that the rental agreement is the backbone of your relationship with the landlord or tenant. Whatever clauses you may include therein would be your deciding factor in the court of law. Moving on, a lot of NRIs are residing abroad with properties situated in India which they intend to lease out or have already leased out. Thus, it is of utmost importance for landlords to know their rights as a landlord towards their tenants. The first and most basic right as the owner of the property is to charge rent. Not only charge rent, but also a periodic annual increase in your rent can be a part of your rental agreement. Secondly, a landlord can at any point of time repossess the property from the tenant for reasons like renovation or upkeep of the property, though only temporarily. Thirdly, the most fundamental right of the landlord is eviction of the tenant. But this eviction of the tenant can only be done in consonance with the prevalent laws. In our country, each state has its own rental regulations. Majorly, it is the same with minor differences. For example, in Karnataka, a landlord cannot get the tenant evicted on the basis of personal bona fide need. The various grounds on the basis of which a landlord can get the tenant evicted are, first of all, non-payment of rent, which is a serious default on the part of the tenant. Secondly, in case the tenant sublets the property to any third party without prior permission or written consent from the landlord, he shall be liable to be evicted. In case the landlord has to carry out any sort of construction at the behest of the local authorities or the state government, he can again ask the tenant to vacate the said premises. Fourthly, in case the tenant is causing any kind of nuisance to the neighborhood or is using the property for unlawful purposes or purposes not mentioned in the rental agreement, he shall be liable to be evicted from the property. Another valid ground available with the landlord for evicting the tenant is in case he needs the property for his own personal bona fide need. Personal bona fide need herein means that the landlord or any of his relative require the premises for their occupation and usage. But this ground can only be used by the landlord in cases where he has not got any such similar property in any such similar area vacated prior to this. Now that we are talking about rights of the landlords, we must also talk about rights of the tenants. The tenant's primary right is the right to fair rent. That means that the landlord cannot charge exorbitant amounts of rent from the tenant. Secondly, the right to basic amenities. Basic amenities means right to water, electricity, etc. The landlord at any point of time cannot deny the tenant the basic utilities that should be present on the premises. Even in cases where the landlord intends on evicting the tenant, he shall not deny him these basic amenities. In case he does resort to such means, the tenant has the right to pursue criminal legal action against the landlord. Thirdly, and the most important, a tenant has a right against unfair eviction. This is a repetition of the grounds that I have already told you about. Thus, the landlord must follow due procedure of law in order to get the tenant evicted. Herein, I would also like to add that in cases the landlord files for eviction on the basis of non-payment of rent, but the tenant decides to deposit the arrears as assessed by the court or the controller within a stipulated amount of time of receiving the notice, then the rent shall be deemed to have been paid. In this scenario, the tenant shall not be dispossessed of the property. Secondly, in cases where the landlord files for a suit of eviction on the basis of personal bona fide need but does not use the premises for his own usage or occupation, the tenant can apply to court for restoration of possession of the same in case the landlord has let out the property to a third party. Finally, if the court feels that any application filed by the landlord for eviction is vexatious or frivolous, then the court can go on to impose a penalty and also compensate the tenant on behalf of the landlord. Finally, now that we are talking about disputes between landlords and tenants, one might wonder if these disputes are arbitrable in nature or not. This has been clarified by the Supreme Court of India in the Durga Trading Corporation case, wherein the court has laid down that the main law governing the relationship of landlords and tenants is the Transfer of Property Act. Transfer of Property Act deals with actions in personam and not in rem. In layman's language, this would mean that these actions are against an individual and not against the society at large. Thus, if there is an arbitration clause in your agreement, it is absolutely up to the parties to invoke this clause or not. The world seems to be beholding an aberrant situation, the effect whereof can be felt not only on our social, political and organizational fronts, but also in our interpersonal relations. A prominent question doing the rounds is that can the tenant seek waiver from the landlord of the rental amount due towards him for the period of lockdown due to the COVID-19 pandemic situation. This means that can the tenant seek waiver of non-usage of a property temporarily. The courts over time have laid down through various pronouncements that no, the tenant cannot seek a waiver for temporary non-usage of any property. Herein, the courts have also dealt with the force majeure clause, and for this have gone into the relevant sections of the Transfer of Property Act and the Indian Contract Act. Force majeure in simple language is known as the act of God. This is mostly included in our rental agreements and has also been provided for under the Transfer of Property Act and the Indian Contract Act. Relevant sections such as 108BE of the Transfer of Property Act, Section 32 and 56 of the Indian Contract Act have been delved into deeply by the courts while deciding whether tenants can seek waiver for temporary non-usage of a property due to an act of God, like the COVID and pandemic situation. The answer is no, because to invoke Section 108BE or Section 32 and 56, the property must completely undergo destruction. Now, this also means that the tenant is claiming a waiver on the basis that the premises are now unfit for habitation and usage. Thus, if a tenant wishes to continue to use the premises and seeks a waiver only for a temporary non-usage, this shall not be provided for under the law. This brings me back to the beginning of my video, wherein I said that the rental agreement is the backbone of your relationship with your landlord or tenant. It is absolutely covered by the Latin term consensus ad idem, which means agreement between parties. Thus, if there are any terms and conditions and you want to leave no ambiguity about the rights and obligations between both the parties, please include that in your rental agreement. Thus, if a waiver clause is there in your rental agreement, go ahead and invoke it. Hope you found this video informative. Kindly do not forget to like, share and subscribe to our channel for more legal updates. You can also ask us any questions that you have in the comment section below, or you could even write to us at query@nrilegalservices.com. Thank you. Stay home, stay safe.